Hello, everyone, and welcome to another episode of the Forge of Freedom podcast. I'm your host, Alex Ooley, and this is episode 165 of the Forge of Freedom. Today, I've got a firearms-related topic for you. It's the topic or the concept of national reciprocity that I want to discuss today. And I want to point out that a number of other firearms commentators have discussed this issue, and people I respect have discussed it. Andrew Branca, William Kirk with Washington Gun Law, Guy Relford, who's with the Gun Guy. He's got the radio show on WIBC in Indianapolis. And I think that these are, like I said, these are people that I respect, who I think produce great content and information. But I think there's something missing in most of the conversations about this topic. And actually, the person who's gotten closest to this issue is Guy Relford. On his show, he discussed national reciprocity and, in particular, a recent bill that's been proposed, actually reproposed. It's been proposed on numerous other occasions and in previous years, and that's this bill, H.R. 38, which I'll link to in the comments, that was proposed by Representative Richard Hudson. And I'm going to read the press release from his website. He's a representative, U.S. representative from North Carolina. And this bill has quite a bit of support. And obviously with the recent election of Donald Trump and confirmation that the Republicans have control of Congress, there is a much higher likelihood that something like national reciprocity or some pro-firearm or pro-right to keep and bear arms legislation could be passed. But this is, unlike many of the firearms commentators and people who support the right to keep and bear arms, I'm not as enthusiastic about this bill. And I want to say why, and this is the part of the conversation that I think is mostly missing from the pro-2A, pro-individual liberty commentary. And that is that I think it's a little bit of a Trojan horse. And I'm going to explain that here in just a little bit. But first, I want to explain what I'm talking about. And to do that, I'm going to just read the press release from Representative Richard Hudson's website. It's the press release issued just a few days ago, January 8th, 2025. Today is January 13th that I'm recording this podcast. And it says, after being sworn into the 119th Congress, U.S. Representative Richard Hudson from North Carolina led over 120 of his colleagues in introducing H.R. 38, the Constitutional Concealed Carry Reciprocity Act. And like I said, I'll link to this press release as well as the bill itself. This bipartisan legislation would provide nationwide reciprocity for concealed carry license holders and for residents of constitutional carry states. Our Second Amendment right does not disappear when we cross invisible state lines, and this common sense legislation guarantees that, said Representative Hudson. The Constitutional Concealed Carry Reciprocity Act will protect law-abiding citizens' rights to conceal carry and travel freely between states without worrying about conflicting state codes or onerous civil suits. I am proud to see such strong and widespread support, and I will not stop fighting to get this legislation signed into law. H.R. 38 allows people with state-issued concealed carry licenses or permits to conceal a handgun in any other state. It also allows residents of constitutional carry states to carry in other states. Read an exclusive story in Fox News here, and there's a story linked to Fox News. I'm not going to go to that. He goes on, Representative Hudson has introduced the bipartisan Constitutional Concealed Carry Reciprocity Act in previous years. In December 2017, the bill was passed by the House with bipartisan support, yet it was not taken up in the Senate. Representative Hudson has repeatedly said he would continue to pursue the legislation. Additionally, President Donald Trump has committed to signing national concealed carry reciprocity legislation into law. H.R. 38 is supported by major pro-Second Amendment organizations, including the NRA, Institute for Legislative Action, Gun Owners of America, the U.S. Concealed Carry Association, and the National Shooting Sports Foundation. The U.S. Supreme Court has repeatedly affirmed an individual's fundamental right to keep and bear arms, said John Comerford, Executive Director of NRA ILA. Congress should now ensure that the right to self-defense does not end at a state line. NRA applauds and thanks Representative Hudson for his long-standing and unwavering leadership in the fight for right to carry reciprocity. Congress has the opportunity to deliver the greatest legislative victory for the gun rights movement in a century, and President Trump has already voiced his support, said Aidan Johnston, GOA Director of Federal Affairs. With all 50 states now issuing concealed carry permits, 49 states allowing non-resident carry, and 29 states with permitless or constitutional carry, it is simply common sense for Congress to ensure that each state's concealed carry license is valid in every other state. We thank President Trump for his leadership on this issue and urge Congress to swiftly send Representative Hudson's Constitutional Carry Reciprocity Act to the President's desk to be signed. On behalf of the USCCA's more than 850,000 members nationwide, we applaud Congressman Hudson's continued leadership in defending the rights of responsibly armed Americans, said Tim Schmidt, president and co-founder of USCCA. Our constitutional rights do not end at state lines. This legislation is critical to ensuring law-abiding gun owners' fundamental right to defend themselves and their loved ones, regardless of geography or location. The USCCA remains committed to seeing H.R. 38, the Constitutional Concealed Carry Reciprocity Act, one of the most consequential reforms for gun owners nationwide, signed into law. And then finally, this legislation eliminates the confusing patchwork of laws surrounding concealed carry permits that vary from state to state, particularly with regard to states where laws make unwitting criminals out of legal permit holders for a simple mistake of a wrong traffic turn, said Lawrence Keene, NSSF Senior Vice President and General Counsel. It safeguards a state's right to determine their own laws while protecting the Second Amendment rights of all Americans. We thank Representative Hudson for his leadership on behalf of America's hunters and recreational shooters. For the full text of the bill, click here. And like I said, I'll link to the not only this press release, but also to the bill itself, H.R. 38. Now, that all sounds great, and it obviously has a ton of support from these pro-2A organizations, GOA, NRA, National Shooting Sports Foundation, USCCA, and others. I know that the Citizens Committee for the Right to Keep and Bear Arms has also come out in support of it, which is an affiliated organization with the Second Amendment Foundation and others. So this is widely, almost universally supported within the 2A rights, the right to keep and bear arms community. But like I said, I actually have mixed feelings about this. I think that it's almost certainly a short-term gain. My question or my concern, my skepticism is how this will be treated long-term. And when I say it's a short-term gain, I mean particularly for people who routinely travel to states where their license to carry a firearm is not recognized. I'm from Indiana. I have a license to carry a handgun in Indiana, and our license is recognized in a number of states. Indiana is also a constitutional or permitless carry state. But there are many states that still do not recognize the license from Indiana. And, I would certainly love the convenience of being able to travel wherever I want without worrying about being arrested for exercising my fundamental natural right that's protected by the Second Amendment, that right to keep and bear arms. But the problem is, and to give some perspective here, I want to give just a brief overview, a little reflection on what the Second Amendment was meant to do, and how we got to where we are today. And I did a whole episode on the Second Amendment, the history of the Second Amendment, and where we are today. And I'll link to that in the show notes. But just briefly, the Second Amendment and really the entire Bill of Rights, the first 10 amendments to the Constitution, were adopted to restrain the federal government. They were not meant to apply to the states or to state government action. It was only to federal government action. And this point came up in an episode I did with Jacob Harnberger about his book, The Tyranny of Gun Control. He said the Bill of Rights may have been more properly called the Bill of Prohibitions. That is, there are prohibitions on the federal government. They don't give us, the people, any rights. And so I think that in itself causes some confusion. It's not the government granting us or giving us rights. It's simply these amendments were meant to protect pre-existing rights that we had, natural rights that we had as people derived from God or our humanity. And these Bill of Rights were really bills of prohibition on the government from infringing on those rights. And so I think more properly understood, that's how we should think about the Bill of Rights as a prohibition, limitations on the federal government, at least at the founding. And it wasn't until after the Civil War and after the 14th Amendment was adopted, really not until the early 1900s, that the Bill of Rights began to be applied through the 14th Amendment to the states and to state government action through a doctrine called incorporation, which I should set aside an entire episode just for that topic itself, the doctrine of incorporation. But the Supreme Court, through a series of cases, has incorporated components of the Bill of Rights to apply not only to federal government action, but also to state government action. And relatively recently, at least within the context of Supreme Court jurisprudence, the Supreme Court incorporated the Second Amendment to apply to the states through the City of Chicago versus McDonald case, or the McDonald versus the City of Chicago. And in that case, the Supreme Court said that the Second Amendment is an individual right, building on the Heller case from 2008, and it's incorporated to apply not only to the federal government, but to restrain state governments from infringing on the right to keep and bear arms. So it wasn't until 2010 in the McDonald case that the Second Amendment was incorporated to apply not only to federal government action, but also to state government action. And I think that background is helpful to keep in mind because most people assume that the Bill of Rights applies to restrain state government action, and that's just not the case. In fact, the states at the time of the founding were concerned about maintaining their autonomy, and they were concerned about the danger of having a highly centralized and powerful federal government. And so they didn't want a federal government that had the authority to make laws or to engage in lawmaking or police power, exercising police type powers within the states. And so that's why the Bill of Rights was adopted. It was a bill of prohibitions against the federal government, but the states didn't want to be bound by the same restrictions as the general government. That was the purpose of federalism, was that we could have these free and separate states that were sovereign and could make their own laws and could more appropriately represent the people who lived in their states as opposed to a highly centralized federal government. So why do I mention all of this in the context of national reciprocity? Well, national reciprocity would obviously compel certain states to recognize licenses or recognize the rights of people in constitutional carry states, those who may not have a license, to carry in their respective states. So if I were, obviously I am a resident of Indiana, if I were going to travel to New York, this bill, this HR 38, would require New York to recognize my license and recognize from Indiana, and recognize my right to carry in New York. Now, that obviously is applying the right protected by the Second Amendment, the right to keep and bear arms, to the states. And so and that's perfectly consistent, I think, with the Heller decision, and then later the McDonald decision. And we can quibble about whether or not the doctrine of incorporation is a legitimate doctrine. I don't believe that it is. I'm at least very skeptical of it. I'm open-minded about it, but I'm very skeptical of the doctrine of incorporation. I think it's mostly a judicially created doctrine that has very little basis in the historical precedent and in the legislative history. But nevertheless, that's almost a foregone conclusion at this point. Nobody is questioning, very few people are questioning the doctrine of incorporation. But the problem I've got is that this national reciprocity, by adopting this bill, yes, it's forcing states that are anti right to keep and bear arms, anti individual liberty, to recognize those rights and to recognize the rights of people who travel into their states to continue to enjoy those rights. But it's also acquiescing that the federal government has the authority to opine or to weigh in or to exercise authority on this particular issue, which is great while you have mostly anyway, a gun-friendly president, although he's had a little bit of a checkered past on the right to keep and bear arms. You have a Republican Congress, and you have a relatively gun-friendly Supreme Court, although each have their own problems with respect to the right to keep and bear arms. But nevertheless, as compared to a Biden or Harris administration, as compared to a democratically controlled Congress, and as compared to a Supreme Court that could weigh more in favor of the progressive wing of the court, it's these various branches of government are relatively gun-friendly. It seems good that the federal government could weigh in on these issues. But the problem is, what happens when the composition or the person in the White House changes? What happens when the composition of Congress changes? What happens when the composition of the Supreme Court changes? There's this precedent then, if this legislation passes, that the federal government has the authority to weigh in on these issues. And they could then potentially not only make a constitutional amendment, getting rid of the Second Amendment, but they could reinterpret the Second Amendment if they don't overturn the Second Amendment or repeal the Second Amendment. But they could also say that, well, the Second Amendment doesn't really protect an individual right, or they could impose standards at the federal level that say, oh, yeah, there's this right to keep and bear arms nationwide, but it's subject to certain conditions. You have to undergo background checks of some sort, or you have to go through mental health evaluations, or you have to have a real ID with some radio frequency enabled identification, or things like this. So you're sort of letting the fox into the hen house, so to speak, as opposed to now we have a system that, yes, is a patchwork of various states with varying degrees of infringements on individual liberty, but at least you have states who can serve as refuge in a sea of tyranny. Whereas if you have a system where things begin to be dictated from the federal government, it becomes harder and harder to find that refuge. And so, like I said, I think that this is largely applauded and people are excited about this idea of national reciprocity. But I wanted to bring this perspective to it because I don't think that we should be so, I don't know, so go into this with so little reservation. I'm always skeptical when we use the arm of the federal government to weigh in on any issue. Now, like I said, for now, they're using it in a way that is favorable. But like I said, we're acquiescing that they have the ability, the power, the authority to weigh in on the issue at all. And that's what concerns me. I think that this doctrine of incorporation has opened up this can of worms. And then obviously Heller and McDonald and now Bruin, which is the decision by the Supreme Court arising out of a case from New York, which said that you have a right to carry in public and basically overturned may issue licensing regimes, has led us down this path to more federal government involvement in the right to keep and bear arms. And one issue that I want to mention is that the right to keep and bear arms, or rather the Bruin case, said in a footnote, and I'll pull this up here and I'll just read the footnote directly. This is on page 36 of the opinion in footnote 9. It says, to be clear, nothing in our analysis should be interpreted to suggest the unconstitutionality of the 43 states shall issue licensing regimes. So the Supreme Court has basically said, and they didn't determine this, but it was in a footnote. It wasn't part of their holding. But they're basically saying that we're going to uphold shall issue licensing, which I believe is unconstitutional as well. But the Supreme Court has nevertheless said that they will uphold these. So that's why I think that this H.R. 38, partly anyway, is being supported or seems to have the most broad-based support, as opposed to legislation like that opposed by Thomas Massie, which I believe is actually the better legislation, but still suffers the same problem with respect to the federal government involvement. Thomas Massie has proposed basically nationwide constitutional carry. That is, no license would be required to carry nationwide, as opposed to a national reciprocity bill like that proposed by Representative Hudson. But I think the Supreme Court would be less likely to uphold a challenge, or less likely to support Thomas Massie's bill, given that they've said that they're not going to or that they have expressed some reluctance to overturning shall issue licensing regimes. So anyway, that's my 2 cents. If you look at, there's a great article at the 10th Amendment Center that goes into this in a little bit more detail. It's an article by Suzanne Sherman. It was actually published August 14th, 2017, back when this reciprocity bill was proposed, I believe for the first time, but at least proposed a number of years ago by Representative Hudson, again back in 2017. And she draws out some excellent points here, has some great quotes from the time of the founding about not only the problems with incorporation, but also what the Bill of Rights was meant to do. And I think that we should at least consider and take some time to reflect on these concerns before wholeheartedly endorsing national concealed carry reciprocity. So one thing And I'm sympathetic to the National Concealed Carry Reciprocity movement. I think that, like I said, it sounds great, at least in the short term, but it goes against the original vision that the founders had of a federalist system of government with a general government in the form of the federal government that had very few and defined powers, and in fact had a provision in the Bill of Rights that said the government could not infringe in this particular area the right to keep and bear arms. Again, I think properly understood as a prohibition rather than a right. It's a prohibition on the federal government. And this article, I think you'd be well served by reading it. So I'll link to it close to the top of the links in the show notes. And a lot of people compare the issue of national reciprocity to the issue of a driver's license. But the driver's license, number one distinction is that it doesn't entail an individual right that's defined or identified in the Bill of Rights, although there are a number of other individual rights that are not identified in the Constitution, and the founders left open the possibility that there could be a number of other rights not identified. It wasn't an exclusive list that were included in the Bill of Rights. Nevertheless, the right to keep and bear arms is explicitly identified in the Bill of Rights. The right to drive or to freely move is not. But the other, in that way's in favor of, protecting the right to keep and bear arms more than a driver's license. But the other thing is that the driver's licenses are recognized between the states voluntarily. The states have decided to do that. It hasn't been imposed by the federal government. I think a more appropriate analogy is the marriage license issue. And by the way, I don't think the federal government should be involved in either marriage licensing or licensing with respect to the right to keep and bear arms. I don't think that any form of government, county, state, city, federal government at any level, should be involved in marriage licensing or licensing the right to keep and bear arms. Nevertheless, government at the state level and the federal level has intervened on the issue. Obviously, there was back in the Obergefell case, which was decided in 2015, the Supreme Court weighed the issue about whether or not states had to recognize same-sex marriages from other states. And the Supreme Court, I think, said there, I'm going to pull it up here, being married in one state but having that valid marriage denied in another is one of the most perplexing and distressing complications in the law of domestic relations. Leaving the current state of affairs in place would maintain and promote instability and uncertainty. I think you could substitute here basically the right to keep and bear arms in place of marriage, and you have the same concern, right? Having a patchwork of laws state to state is a perplexing and distressing complication, and it promotes instability and uncertainty with respect to the exercise of the right to keep and bear arms. Nevertheless, it doesn't mean that the federal government should weigh in on the issue, and I think that we've seen that on firearms, the Supreme Court and the federal government may be on our side today, but think back to the marriage issue. Now there are states who are compelled to recognize marriages that people in their state do not want to recognize. And so I think that that's the more appropriate analogy when thinking about the right to keep and bear arms, is the same-sex marriage issue from 2015 that was addressed in the Obergefell case from 2015. So I hope that this gives you some food for thought. Like I said, there's a few different flavors of this. The most, it seems like the one with the most traction is this HR 38 from Representative Hudson, which is a nationwide national reciprocity bill. I think this is the one that's most likely to pass. This also, interestingly, uh, has an attorney fee provision. So if you travel to a state that uh, violates the statute that doesn't recognize your license and requires litigation, you would be entitled to attorney fees. So that's an interesting. It's got some teeth to it in that way. There's also the one I mentioned from Thomas Massey, the National Constitutional Carry. As I said, SCOTUS, the Supreme Court, has already alluded that they would likely hold up shall issue licensing. So I think this type of legislation is less likely to pass. And then you could also have a situation, a third flavor, where there's some sort of federal license. I don't think that's likely either, but nevertheless, it's something that could come up from time to time. I think this bill, HR 38, is the most likely type of legislation to pass. And I just want to, I'm not telling you not to support it. I don't think you're crazy if you do support it, but I do have some reservation about it, and I want people to think about these issues before you decide to write to your congressman and say you wholeheartedly support this legislation. Think through these issues, because I think, unfortunately, our federal government has become so large and so powerful, it's hard to turn back time to the form of government that our founders originally envisioned. But I think it's also possible to stem the tide of an all-powerful federal government, which I think would obviously be bad for the right to keep and bear arms and individual liberty more broadly. So, with that being said, I'll link to. I'd actually encourage you, obviously, to read the article from the 10th Amendment Center, and I'll also link to the podcast episode by Guy Relford as well, where he discussed this issue. Like I said, he touched around the edges here on this issue, alluding to the 10th Amendment and the Ninth Amendment. I think should be appropriately mentioned as well. But Guy Relford alluded to the 10th Amendment and that he's got some reservation about addressing this issue through legislation. He thinks it's more appropriate to address it through court, through the judiciary. But I think it's problematic to have the federal government weigh in on this issue, no matter which way it happens, whether it's through the legislative branch, the executive branch, or the judiciary. I agree that the judiciary is the better of the three to weigh in on the issue generally, but I think it's bad for the government to be involved more broadly. So, with that being said, I hope you got a little bit out of this episode. If you did, don't forget to like and subscribe. And as I alluded to at the beginning, I think I need to come to this topic. I've been resisting it for a while because it's such a kind of an obscure area of the law, but it's incredibly important, and that's the topic of incorporation. So I think I'll do an episode on that sometime in the near future. But like I said, if you enjoy the episode, don't forget to like and subscribe. That helps us reach more viewers who might enjoy this content. You can find the episode on YouTube, Facebook, Rumble, and X at Forge of Freedom. You can also find it at forgeoffreedom.com. Until next time, remember, you are the Forge of Freedom.